We are recording right now. Welcome to our presentation today, Expecting Trouble After You Pass, Special Protection Clauses for a Trust. My name is Connor Clemens. I'm an estate planning attorney at Cunningham Legal, and we have Jim Cunningham as well. Hi, Jim.
Morning. Good morning. And I hope nobody is expecting any trouble after you pass away, but unfortunately, it happens a lot. And so that's why we're doing this really important webinar here today.
Okay, so really before we jump in, we have to give you our disclaimer. Everything we talk about today is purely for educational purposes only. It's not legal advice. After today's presentation, we're going to invite everybody at this webinar to do a one-on-one appointment with us at a later date. And at that meeting, we'll be giving you legal advice. But today's presentation, totally educational only because we have not seen your unique situation and your unique documents.
And by the way, if you guys have questions, there is a Q&A at the bottom of your screen. You can put it in chat. Q&A is a little bit better in terms of answering the questions. So there's that Q&A button at the bottom. Feel free to ask any questions that you have as we go through the material, and we can answer those.
So Cunningham Legal, we have offices throughout Southern California and Northern California. But of course, due to COVID-19, we have been doing quite a few meetings by Zoom. We are available by Zoom. We have our 7 different attorneys throughout California. You see Jim, the founder, the president. He founded the firm, I think in what, 1994, you said? 94?
Yeah, basically when I became a lawyer.
Yeah, and then Jim has Savvy Estate Planning, which is his best-selling book on estate planning. I do estate planning. My practice is totally intact. So you can see Jim's book there. It is on Amazon.com. Really easy read. My background is in tax. But I practice estate planning. So estate planning is going to be preparing for incapacity, preparing for eventually passing away, and for preparing for somebody to inherit. And that's what we're really going to talk about today, is preparing to inherit. And I always tell people, estate planning, it's kind of like idealistic. It's almost romantic. People have this very pure idea of how everything goes when they pass away. And it isn't always reality. And our job as estate planners is to try to pull you back to reality. So today we are going to go into these estate planning traps that people fall into when they pass away. 3 of them, really, to be precise. But let's start off with this first one, spendthrift trusts. So a spendthrift trust is a type of trust that either limits or altogether prevents a beneficiary from being able to transfer or assign his or her interest in the income or the principal of a trust. So what does that mean? Well, Jim, why don't you explain it in a little bit easier to understand terms?
Well, yeah. So I've had clients in the past, they say, my son is 25. He's living in Maui, smoking weed all day and surfing. He's not really doing anything with his life. And when I die, I don't want to give him a big pile of money and, have him be able to just blow it, quite frankly. And so one of the benefits of a spendthrift clause, and that's why it is called a spendthrift trust, right, is you have the spendthrifts, people who just spend money, and you want to control that money. And so the basic element of a spendthrift trust is if money is being held by a trustee for a period of time, and this is the person kind of like an executor of a trust, if a pot of money, if an inheritance is being held, the person who's inheriting the money can't sell that right to inherit, can't, with the technically hypothecate, borrow against it. They can't use it as collateral. So the basic idea is you have a pot of money that the beneficiary can't get access to because they're living in Maui, surfing all day. So,
and these trusts, they provide asset protection. Like not every person who's going to be a beneficiary of a trust, not all of them have these issues where they are spendthrifts themselves, but they still want asset protection in case they do get sued, or in case they get divorced, or in case they have a creditor. And if you look at your trust that you already have in place, assuming you have one, you'll see your trust has this spendthrift protection set up where it says that it can't be assigned. And we'll go through that a little bit later today. But really, it's not like this is a separate type of trust. If you have a revocable trust, almost certainly you have this spendthrift clause built in, which makes your trust a spendthrift trust. But not all these spendthrift trusts work as intended. So we're going to go a little bit into that. If a trust incorporates a spendthrift clause and the beneficiary is precluded from transferring his interest in either income or principal, so that's going to be the trust contents, then the beneficiary's creditors will not be able to reach the beneficiary's interest in the trust. So if you have a son and you die and your money goes to him in trust, and the beneficiary is precluded from transferring his interest to a creditor, then that money is generally protected. So I'm going to dive into that a little bit deeper. This only protects property that passes through a trust. So if you have an IRA or a 401k or life insurance proceeds or policies that do not funnel through the trust, they're not going to be provided this spendthrift protection. They don't have this protection from creditors, and that's just because they're not part of the trust.
Yeah, I'm really glad you mentioned this, Connor, because so many of our clients have very large IRAs. A lot of our clients have a lot of life insurance, and many times those assets are paid directly to the beneficiary, or they, in some cases, for some of our clients, they've done IRA legacy trusts, which is kind of like a living trust for your IRA, but it's not a living trust. Separate planning that does protect from creditors, but most instances that we see, the direct beneficiaries get that 401k, get that IRA, and that is not covered by the spendthrift provision. So if you want to have some protection for your heirs, if you think that there's going to be trouble with your loved ones when they inherit and their financial situation, their divorce, right, their bankruptcy, then you need to understand that the spendthrift provision does not cover assets that pass outside of the trust.
Yeah. So keep in mind that once that property has been distributed to a beneficiary, and even if it does come from the trust itself, that property can be reached by a creditor, except to the extent that it's used to support the beneficiary. So this is a little bit complex, but I think you all can handle it. The support standard is a standard set up by a court. It's totally subjective based on, or maybe not subjective, but it's always unique based on how much money the beneficiary has and earns. That there's a certain money that is safe, but anything above that low threshold is totally free to be taken by creditors. So that's why people leave money in trust, to prevent this money from being taken by creditors. All right, so going through, if a trust calls for a distribution to the beneficiary, but the beneficiary refuses such distribution and elects to retain property in the trust, the spendthrift protection of the trust ceases with respect to that distribution, and the beneficiary's creditors can now reach assets. So that is from the probate code itself.
Let me translate. Here's what's going on. Most trusts that we see say that when the person who set up the trust dies, there is a period of time where you have to settle the estate. And it's very important to understand, when somebody dies, this stuff just doesn't happen overnight, automatically, instantaneously. There is a period of time that goes by, and sometimes it's 6 months and sometimes it's a year. And it depends, because you have to, first of all, collect all of the assets when somebody passes away. You have to pay all the taxes and expenses, and just collecting the assets and figuring out what's owed, that takes time. And then you make distributions. Well, when, let's say during the time that a person has created a trust and has passed away, and now we're in this administrative period, a beneficiary, one of the heirs, let's say that beneficiary gets into some creditor problems, maybe is going through a divorce, maybe going through a bankruptcy. And what that beneficiary says is, oh, wait, trustee. I know the trust says that when it's time to distribute the property, you should distribute it to me. But I don't want you to distribute this money to me because I have this problem going on. And if I receive this money, it's going to get paid to my creditor. So you know what? Let's just kind of do a nod and a wink, and trustee, I'll just refuse to take that, because you have to accept, I'll just not cash the check. You can write the check, but I'll not cash it. The creditor in that case can come in, and when it's time to distribute the money, you can't play games. It's not that easy. All right. The creditor can come in and take that money from the trust. Okay. So it never even hits the hands of the beneficiary. Does this happen? Yes. Does it happen often? No. But it's a big deal when it does happen, and it can be several $100,000 or several $1 million, right? Depending on the size of the debt and depending on the size of the inheritance. So that's what's going on. There is no easy end run, quick, nod and a wink, kind of wipe it under the carpet. That approach does not work with spendthrift trusts.
So these spendthrift trusts, the clause itself, I see it in almost every trust. Jim, you must see it in every trust you look at.
Yeah, I mean, it's like saying, has a car ever been made without any window?
Yeah, sure.
I suppose someone's made a car that has no windows, but, generally cars have windows. And this is to our point now. If someone does a homemade trust, If they go, hey, I'm just going to cobble together a trust on my own because I'm a smart engineer, I can do this. It may not have a spendthrift provision, but most lawyers who draft trusts, and frankly, even most paralegals that draft trusts, do have a spendthrift provision in.
Their default.
But it's fairly weak. But I think the point here is it's fairly weak. You shouldn't rely on it as an asset protection strategy.
The default is that you have to couple it with the right distribution language. So we're going to specifically show you the distribution language we're talking about. So here is a spendthrift provision. This is from an older trust, probably from the early 2000s, not a Cunningham Legal trust, but this is totally common. It looks very similar to ours. And you can see no interest in the principal or income. So in the trust, essentially, no money in the trust can be encumbered or pledged before actual receipt by a beneficiary. So it can't go anywhere as long as it hasn't been received. And you get the rest. So it's saying that this is what a spendthrift provision looks like. I'm not going to go too in depth, but you have to couple this with the distribution language itself. So we're going to go to the real distribution language from this very same trust.
And it's important to understand that while the trust administration is going on, before the property is ready to be distributed, remember, you have to collect the assets, you have to pay the debts and expenses, and only then, step 3, do you make a distribution. What we're talking about is during step 1 and 2, because here's what you don't want to have happen. Let's say you do have a creditor issue with one of the beneficiaries. Mom and dad die. In the next week, you don't want the creditor coming in and telling the trustee how to do the trustee's job. That's kind of the point of the spendthrift provision. But once it's time for distribution, different story, and that's what this paragraph is about.
So right when that step 3 comes up, the trustee shall divide the trust asset into these many shares, and each share goes as follows. So I'm showing one share here. You can see it. The trustee shall distribute one share to Blake if he's living. If he's deceased, it goes to his kids. And that's essentially it. This is an outright distribution. So as soon as step 3 is reached, even if Blake is going through a divorce, or if Blake has a creditor through a bankruptcy, or he's being sued, his money is now available to the creditor because that's how the trust was set up. It gives him that asset protection from steps 1 and 2, but not once he hits step 3.
Yeah, and what's going on here? This is a typical provision where what we see is the trustee takes that inheritance and stuffs it into the pockets of the beneficiary. And it's been said, if you love someone, you'll never leave them anything. If you love someone, you'll never leave them anything. You're going to want to leave it in a different way that Connor's going to talk about. Rather than putting it in their hands, you need to protect it.
And I'll go through one more example as well. See, not all these trusts always look the same. Every attorney prepares their trust a little bit differently. This is a spendthrift provision from another trust. No interest in the principal or income of any trust created under this instrument shall be anticipated, assigned, or encumbered, or subject to any creditor's claims or its a legal process prior to his actual receipt by the beneficiary. So a little bit shorter than the last one, but it's saying the same thing. Unless the beneficiary has received their share, they have asset protection. So the same thing, steps 1 and 2, the administration, they have their asset protection, but once beneficiary receives their share, it's over. And so we go to this trust distribution clause. The trustee shall distribute the trust estate after payments in sum in Article 3 and 11, talking about debts, to the beneficiary or to his issue by right representation. So this just means step 3 is reached, you have to distribute the money, and that is when the asset protection ends. And obviously, in a perfect world, you don't want that asset protection to end at step 3. You want it to continue as long as possible. So that's really what we try to help our clients with, is continuing that asset protection. So I'm going to show us now a Cunningham Legal Trust. This is our spendthrift provision, and you can take a look at it. It looks kind of similar to the first. We just can't have our money alienated to those third parties. It's not subject to the attachment of bankruptcy or any other legal process. But now what really makes that difference is the distribution language. So here we have a distribution for Johnny and his share. So our trustee shall administer the share set aside for Johnny and trust as provided as follows. So ours is different. You can see here our independent trustee may distribute to Johnny as much of the income and principal of his trust as our independent trustee may determine advisable for any purpose. So I'm going to go a little bit into detail here. Our trusts, typically, not all of them, but when our clients want it this way, we name a trust protector on our trust. We typically name ourselves as trust protector. If our clients' beneficiaries are having creditor issues when the client passes away, we do not name the child as trustee. We have the child advise us as to an independent party to serve as trustee so that we can provide furthering asset protection to the beneficiary. Jim, why don't you go into a little more detail?
Yeah, so there's a lot in there that you've just kind of thrown out there. What is an independent trustee? An independent trustee is not the number one, not the beneficiary, and secondly, not a relative. So not an ancestor, a parent, a grandparent, or a descendant, a child or a grandchild, a great-grandchild. It's also not a sibling, but it can be a niece or a nephew. Okay, that's the closest familiar relationship. And then you got to add in marriages too. Marriages count. And that's under Internal Revenue Code 672C. An independent trustee, and is also not employed by the beneficiary. So very important. Someone who's not an independent trustee is what's called an interested trustee. So this would be someone who has a close familial relationship or marital relationship, or is your employee. Now, or you, right? Or the beneficiary. You limit the distributions to health, education, maintenance, and support. Now, those may sound kind of frou-frou-y and, kind of out there, but those are actually well-defined under the Internal Revenue Code. And Connor also mentioned a trust protector. Now, for those of you, I recognize some names on here, and we've done your estate plan, and you do have a trust protector. So for those of you who, have it and don't know what it is or don't have any idea what it is, a trust protector is an individual who has power over the trust, but is not the trustee. So let me say that again. A trust protector is an individual who has power over the trust, but who is not the trustee. And you might say, well, why would I want to give somebody power over a trust that isn't the trustee? Why on earth would I do that? That sounds like a terrible idea. Well, here's the problem. That power exists, whether you acknowledge it or not. It's kind of like science, right? That power exists, and it exists in the court. So the court retains that power over the trust, but a court frankly never serves as trustee, but they do have a lot of power over the trustee and power over the trust itself. And so what we do is we take a lot of that power that is traditionally reserved for the court, and we put that into the office of the trust protector. And that's very, very important, because many ways that you can write a trust that give asset protection, it really helps to have a trust protector. And frankly, the asset protection doesn't quite work as well, or not at all, if you don't have a trust protector who's this independent person who's not a court. And the problem with the court, there's nothing wrong with judges. They're honorable, smart people who are trying to do the right thing. The problem is they don't know you. And many of them, frankly, don't understand this area of the law as well as the lawyers, Connor or I, or frankly you, who are preparing and doing the estate plan. Many times they're just not trained in that area. So we highly recommend that our clients consider, if they're going to do some asset protection for their heirs, and to avoid those troubles in the future, that they look really seriously consider a trust protector. Very, very important, as well as an independent trustee.
Thank you, Jim. And you can see afterwards, if no independent trustee is serving here, we have it written, our trustee shall distribute to Johnny as much of the income and principal of his trust as the trustee determines necessary for health, education, maintenance, and support. So even if you have a non-independent trustee, provided there is an attempt here to give some asset protection, but that asset protection really comes best when there is an independent trustee involved. I always tell clients that in times of peace, we have a non-independent trustee, but in times of war, or when we come close to times of war, we do use that independent trustee. That
reminds me of the movie The Godfather, where the I'm trying to blank on the name of the actor. He was the not the wartime consigliere, right? The lawyer. He was the peacetime lawyer for the family. So similar thing.
Yeah, there you go. All right, so continuing through. Exceptions. Now, people who hear about the spendthrift trust, they might want to set it up for themselves. Now, California, you don't have
wouldn't that be easy? That'd be great.
Yeah, people have tried it in the past.
Yeah, it doesn't work.
Set up a trust, use an independent trustee, and make sure that if they get sued, they have no issue. But California, they prohibit it. However, other states do allow it. People who have watched our past presentations probably recognize some of these states. Delaware, Alaska, and Nevada, they allow those self-settled spendthrift trusts. But even if you set up a trust in one of those states, if you place your California real estate in one of those foreign state trusts, you're not going to get any spendthrift protection. Sorry to say. Now, you can go open up a bank account or a brokerage account in Nevada and start a trust there, and you will probably have decent asset protection, but still, you have to go through those hoops. All right, so how about the sole trustee and sole beneficiary exception? So this is another exception to when these things can end. When a debtor is the sole beneficiary and sole trustee of a trust, the government does not provide any asset protection to the beneficiary. This is known as the doctrine of merger. So once again, this is why we use that independent trustee language. We always leave that option of using another trustee. So this exception can also be defeated with successor beneficiaries. So we always make sure our clients execute a power of appointment to name those backup beneficiaries in case the beneficiary exists with money still left in that spendthrift trust. And our final exception to the spendthrift trust is, I'm going back to this. This is the same slide we showed before. I'm just noting here that the independent trustee, we use that to make sure that that doctrine of merger is never met. That's why independent trustee is there, to make sure that we always give that option, somebody else serving as trustee besides the beneficiary himself or herself. So now, final exception is support payments. So can creditors access anything from a spendthrift trust? Well, almost always, no, they can't access what's in the spendthrift trust. But there is an exception. A court may order the trustee to satisfy a beneficiary's support obligation to a former spouse or for a minor child out of distributions that trustee has decided in his or her discretion to make to the beneficiary. This is due to public policy, because society really wants to make sure that children receive money from these trusts, from these.
Yeah. So yeah, Connor, you hung up there a little bit. But here's what's going on. The courts do not like deadbeat dads. And courts, if somebody owes child support or spousal support, that is going to get paid. You are limited under California law to 25% of the income from the trust. So there is limited protection. But I'll tell you, I'm not, when clients come to me and they say, hey, Jim, I want to weasel out of my support obligation, I'm not a big fan of that. It's the opposite of not a big fan. I just don't like that. And, as lawyers, we're supposed to be doing the right thing and keeping society together. So I'll get off my soapbox. But so if you try to come to us and say, hey, I want to weasel out of my support payments, we're not going to do that. So not a good idea.
The courts feel the same way. They don't want people missing those support payments.
Yeah, you got to argue the merits on that. Go back to family law court and make your case. That's the best way to do it.
So the conclusion for spendthrift trust section is just make sure that you review that part of your trust. There are different parts that need your attention, and it's important that an attorney review your situation and discuss these parts with you. All right, so moving on, a little bit simpler part of estate planning is a survivorship clause. Now, do you have a survivorship clause? Now, I don't see these as common as I do the spendthrift provision. I still see it quite a bit, but not every day. So we can look at our survivorship presumption clause here.
But by the way, what are we talking about here? Here's what we're talking about. Mom dies and has a son. The son dies after the mom, but maybe dies before the trust administration is complete, or maybe dies a month after. So that's what we're talking about here, is people dying close in time to the person they're inheriting from. And this actually does happen far more frequently than you might think. And our firm handles about 300 estate administrations a year. And I would say, Connor, this kind of comes up at least once a month. So I would say it's, maybe a 10% probability, and it obviously depends on how many people are inheriting, but this does come up quite a bit.
So this clause here, if any beneficiary is living at my death but dies within 60 days after my death, then the beneficiary will be considered to have predeceased, to have died before me for this trust purpose. So let's go through a little example, a hypothetical. We have a father and daughter in a car accident. The father dies, and 3 days later, the daughter dies. So without this clause, the daughter's estate would inherit the father's share, probably leaving most of her inherited assets to her spouse if she's married, especially if she has a will or a trust in place. It will almost certainly leave it all to her spouse. Now, with this survivorship clause in place, even though the daughter technically died after the father, she died within that 60-day period, and we treat her as to having predeceased the father, and the contingent beneficiary in the father's trust ends up with the daughter's share of the assets. So most likely, the father has said that her share would go to her children if she has children, and if she doesn't have children, it would go to his other children. So he keeps that money in his family through this clause here, and also probably saves a lot of money on a potential probate or spousal petition as well. This clause is, like I said, a little bit less common than that spendthrift clause, but it's still important and can really prevent a disaster in case somebody passes away. All right, and our final clause is the no contest clause.
This is the good one.
Now, this is the one
I think this is why everyone's here.
The no contest clause, this has been around for a long time, and it's been changed really throughout the years.
But
So,
can we just say what this is? Here's what a no contest clause says. If you challenge the trust, you don't get anything. I write an estate plan and I say I'm leaving it to my 3 kids, and I don't want there to be a lawsuit when I die. I don't want my one kid taking my other kid to court. So what I'm going to say is if anyone takes someone else to court or my trustee to court, you don't get anything. That is not a no contest clause, by the way. Going to court is not a contest, and Connor's going to talk about this. So just what I want you to do is think about this. When I meet with a client, they say, I want to keep my family out of court. And so therefore, I want you to put in a no contest clause that says if anyone challenges the trust, they don't get anything. Well, that's actually not what happens. And Connor, why don't you pick that up?
okay, so a little bit of history with the no contest clause. These things were really used quite a bit in the 90s, and they were used so often that even when there were cases of elder abuse, the trust would still have this no contest clause. And so it would almost disservice the family because the family was so worried about suing the trust to take care of their abused parents. So in about the year 2000, the state legislature just got rid of the no contest clause essentially, or maybe not got rid of it, but they made it toothless. That's actually the word they used. They made it toothless. And then they had the opposite problem, which was people were going to court way too much because they could just sue for any little thing they wanted to. So in 2008, the legislator and Arnold Schwarzenegger changed the laws. As of 2010, it became enforceable so that they are narrowly applied. So the first part of this is keep in mind, if you have a 2010 trust, anything older than that, your no contest clause is almost certainly unenforceable. Your trust is not a protected instrument. The 2000
By the way, or an amendment. This is very important to understand. A trust or an amendment done before 2010.
And
not
keep
good.
in mind, like Jim's saying, if you've had an amendment done, that no contest clause has to be on each separate amendment. Even if you had it in your original trust, if it's not on that separate amendment, it is unenforceable for that particular instrument. So 2010 law comes into place. This is the most recent law. And it prevents direct contests that are brought without probable cause. So you guys all watch television, maybe some attorneys on here themselves. You know what probable cause is, or maybe you think you know what probable cause is.
No one knows what it is.
Is it more likely?
Probable cause is from the criminal. This is a criminal term. And when this was passed, I was practicing as a lawyer. Everyone was like, what the heck? Probable cause? Like, who put that in there?
So we know it's more.
I think it was the first time it was put in the civil application. It was borrowed from criminal law. Totally bizarre.
We know it's more than 50%, but I know some people think probable cause is like a 70 to 80% likelihood. Either way, it makes it a difficult question. So next slide, the no contest clause, it prevents direct contests on the grounds of forgery, lack of due execution, lack of capacity. So we're talking about, you know, when a trustee manipulates documents or they force somebody to sign, they take advantage of a person with dementia. Duress, fraud, undue influence, they force them to do it, revocation or disqualification due to a fiduciary relationship, all these things that are brought without probable cause. So go ahead, Jim.
Yeah, let me just camp out here for a little bit. Another way of saying this is if there is probable cause, you can bring a contest and not trigger the no contest clause, okay? Meaning you can, if you do have probable cause, you can file a lawsuit and you won't lose your inheritance, okay? Whatever inheritance you have under there. And by the way, some people inherit a little bit and they think they should inherit more, and that's why some people will challenge it. But something very important to understand is when is probable cause determined? There is no preliminary hearing equivalent from a criminal context. There's no probable cause that's typically found at the conclusion of trial, and the judge says, well, there was probable cause or there wasn't probable cause. That happens after the trial's over. So there's a lot of uncertainty. Basically, everyone has a right to inherit, right? If there's a familial connection, you have a right to inherit. If you've been named in a prior will or trust, you have a right to inherit. So you have the right to sue. So it's very important to understand that no contest clauses don't prevent lawsuits, but they're about whether the person who's filing the contest gets anything from the estate or not. And by the way, if you win, you throw out the contest clause of the document that you're seeking to challenge, right? So if I do a trust in 1990 and I do a trust in 2000 and in 2020 I die, and they throw out that 2000 trust and go back to the 1990 trust, for example, whatever no contest clause was in that 2000 trust goes out with the trust as well. So if you win, you win in that context. So I'll let you take it, Connor.
Yeah, thank you. So exactly what Jim just said. I can't tell you how many clients I meet with that see a no contest clause or they hear about it and they think, well, my kids can't sue the trust. They just aren't allowed to do so. The no contest clauses, they do not prevent the beneficiary from suing. So just to kind of sum up, because I know it's a little bit confusing, all these different parts. The contest clause says if the beneficiary brings a certain type of lawsuit, like that diminished capacity lawsuit, without probable cause that diminished capacity existed or fraud existed, they will forfeit their inheritance. They have to have probable cause during the time the lawsuit starts, during inception of the lawsuit. Otherwise, they will lose their inheritance. They can't just sue and hopefully something comes out during the lawsuit. They have to know that. So once again, this does not mean the beneficiary cannot sue. Now, you might be thinking, what is the point of a no contest clause if it doesn't protect me the way I expected? They do still have a purpose. They act as a deterrent to bring lawsuits. Now, when I have clients that really expect this type of fight, we typically, I don't know, maybe advise is the wrong word, but we seriously consider giving a decent sized or a substantial gift to the beneficiary in order to give the beneficiary something to lose in case they sue. Now, if the beneficiary doesn't receive anything, if you've just straight up disinherited this beneficiary, or you just have failed to address them, they do have nothing to lose. What does it matter if they trip the no contest clause? They're not going to get anything anyway. So each beneficiary is different. $20,000 might be a lot for one beneficiary. For another person, $200,000 might be a lot. So you really have to assess what the beneficiary can afford to lose. Can the beneficiary afford to risk losing $200,000 coupled with legal fees to challenge a trust? Now, another strategy we've done when we worry about these pesky beneficiaries suing is instead of calling for an outright distribution, we use that dole it out distribution that we've talked about on past presentations. So the dole it out distribution, what that is the money comes out at the discretion of the trustee. And the whole point of this strategy is you shift the goal of the beneficiary, the upset beneficiary, to why didn't I receive more money to why don't I get my money right away. So we try to change that goalpost to focus on the dispute being give me my money all now versus I should have got more than that money set out in the trust. So what can the beneficiary stomach losing in the case they tripped a no contest clause? You have to ask yourself that. Now, I have clients all the time that say, oh, out of principle, I don't want to give that person any money. And maybe that is you yourself. But if you really do worry about the lawsuit, you can strategically give out money to try to deter a beneficiary from tripping this clause.
So a couple things on that, Connor. One of the concerns is the timing of making a distribution. So what we've done in the past, and I've done this with clients, is they say, you know, I want to disinherit my daughter. And I always ask why, and I'll touch on why when I'm done with this example. But I want to disinherit my daughter, and I'm concerned she's going to sue the trust. And how do I keep that from happening? And this is what Connor's talking about. One strategy is give her $100,000 or give her $50,000 or whatever the number is, and you got to come up with your own number, you know, given the size of the estate and the percentage that she would otherwise be entitled to. One danger in that is what we call loading the cannon. So, you know, you do not want to load the cannon of the opposition that they're going to turn around and shoot at you, right? And when a person passes away, there's a mechanism that we use and any competent lawyer uses, and you send the person who's getting disinherited a letter basically that says you have 120 days to challenge the trust. Well, you would want to time the delivery of the money to be after that 120-day time period, right? Does that make sense? So you don't want to give it to them right at the beginning, but you also don't want to wait more than a year, because if you wait more than a year, then they're entitled to interest on their specific or their dollar amount gift. And by timing the gift correctly and having it be the right amount, it can act as a deterrent. Now, the question you might have is, well, can they still get the money? Can they still file a lawsuit? Yeah. All right. Will that be dismissed? It will probably be dismissed pretty quickly, but it's something really to understand is you can't keep people from filing a lawsuit, right? That's just not how our system works. The other thing is there is a Texas case out there that says if anyone has received anything from the trust, they cannot challenge the trust. Now, that's not a California case, so even if you said give them 200,000, 2 weeks after dad dies, there is one case out there that says you cannot come back and later sue challenging the underlying document. The other issue I want to talk about is disinheritance, because a lot of the no contest clauses they come about or they're litigated because somebody has been disinherited. And it's very important to understand that people have to be disinherited for lawful reasons. I had one client come to me. She says, I want to disinherit my daughter because she's white and she married a black man. And I said that race is a protected class in the United States, and that is not enforceable. No, I can't imagine any judge in California enforcing, if that is the sole reason, enforcing that order. So because it's a protected class of person. The other one that just came out with the Supreme Court last Monday is the Supreme Court extended equal protection to people based on sex and sexual orientation. And this is something, Connor, you and I have talked about in the past, is some other clients will come in and they say, I don't want to leave my any inheritance to my daughter because she's gay. I don't agree with their lifestyle, and I don't want to do that. I always thought that was an unlawful purpose under California law, because California has already extended those protections. And now it looks like it is also a similarly protected class of person, so that cannot be the reason. So this is very important. This is estate planning is an intersection of who you are and your family and your assets and your personal situation, but it's also an intersection of law and the kind of society that people in the United States and in the state of California come together and agree on what are the rules of living in our society. So it's very, very important. If you are looking to disinherit somebody, I will just say as a general rule, I really try and talk people out of disinheriting somebody. In those two contexts of race and sexual orientation, I will tell you that in meeting with the family after the parent has died, the family, I can't even think of a situation where this has not happened. The family comes together and they're like, yeah, mom and dad had their hangups because they were born in the 1930s or whenever they were born, but we're all fine with it as a family. And, we accept the spouse or this partner as one of our families. So, again, these are my thoughts based on my experience, but if you're going to disinherit somebody, it has to be for a reason. And so there is something called a right to inherit in California. And there's a thing in the law where they say judges abhor a forfeiture. So judges do not like it when people are disinherited. We typically counsel people to have a reason, okay? And document that reason, whether you handwrite a letter or but it should be something in the lawyer's file that says why the person's being disinherited. So just a couple interesting thoughts on disinheriting people.
And Jim talked about those protected classes, like saying if somebody marries a person of a certain skin color or has a gay child, they want to specifically disinherit for that reason. The government doesn't want to enforce those provisions. There are some, I don't know, a little bit more gray area things like we've talked about before, we've seen before. Of course, if you put a provision that says if your daughter or son marries someone from outside their religion, will the court enforce that? Recently, we saw somebody say, I want to give my daughter my house if she's single, but if she's married, I don't want to give her the house. We don't even know if the court will enforce that, because they do not want to, they don't want to risk that marriage situation. They want to encourage marriage any case possible. So just keep that in mind if you are considering disinheriting somebody. All right, so conclusion is a lot of people, they think that the estate planning words in the document are just a bunch of words. A lot of this stuff have been the result of a decade-long struggle between attorneys and legislators and beneficiaries, all trying to make a more righteous system. And part of the reason why people hire us is to analyze unique situations and to give advice as to how you should handle these situations. So like I told you at the beginning of this, we are offering appointments for everybody here today. If you have already done an appointment, that's okay. We can do a phone call. If you've never met with us, I encourage you to take an appointment. We have an office in Pasadena, Westlake Village, Woodland Hills, Huntington Beach, and then Sacramento area, Roseville.
One thing I want to talk about is why kids fight after parents die. And for those of you who've been on other webinars, you might have heard me give this example. Is you know, it's 1962, it's Christmas, and Johnny gets the red bike, the new red Schwinn, and Sally doesn't. And Sally's mad. And Sally's mad at Johnny for the rest of Sally's life, right? So something that happened a long, long time ago, Sally's still mad that Johnny got the red bicycle. So when Sally and Johnny's parents die, Sally uses that as the way to get back at Johnny. So we do see it that people are vindictive and they're trying to settle old scores in you know, decades after something happened. And I will also say this, that if you try and do something, you say, well, I'll just write it this way and I'm sure it'll work out. I'm sure it'll be fine. Everything sees the light of day. And I really mean that. Like everything sees the light of day when somebody passes away, and you look at the estate plan, and people change when, you know, when that generation dies, when the parents die. And my mother-in-law, we had her memorial service a couple weeks ago. And so I'm seeing this in my wife's family is, you know, that next generation, things are different. And, you know, people say, oh, it's not about the money. And, you know, whenever somebody says it's not about the money, it's about the money. But people really can have a hardened heart, and it does become literally about dollars. And Connor, when I was your age, you know, a generation ago, and I started doing trust and estate litigation, I started doing contested work. People just didn't sue that much. Now, you know, it's pretty much, you almost have to anticipate that there's going to be a lawsuit after somebody passes away. So looks like we have no questions. We'll give it going once, going twice. Thank you.
Let me find a quick note. I also think that a lot of the times when somebody passes away, when a parent passes away, the kids, not all kids, but plenty of kids, their true character shows because there's no longer a watchdog. So that potentially happens too. And I tell this a lot to my clients who have grandkids. This is not all people who have grandkids. But in my experience, for a lot of people, the relationship between the grandparent and the grandchild is a unique relationship where both the grandchild, like they think of their grandparent in a way nobody else in that grandparent's life has ever thought of them. And the grandchild too. They just have like this heightened relationship where they really think the other one's perfect. And you have to make sure that doesn't affect your estate plan in a negative way.
Words of wisdom. All right, guys, thanks for attending today, and check us out. We've got more webinars coming up, great webinars, and we'll see you guys soon.
Yeah, thank you.